Hello guys. Now we move our discussion further, move on to what is permanent injunction and what are the temporary. We already discussed permanent injunction in the first part of this video, and now move on to temporary injunction and permanent and the mandatory injunctions. So the temporary injunction and what it says and how can we one understand the temporary injunction is restraining a party temporarily. It is not a permanent in nature, and it can temporary injunction means a partial restrictions from doing any specific act, और ये कभी भी ग्रांट कर सकती है कोर्ट between the trial before the summon of defendant or when there is an initial hearing also, if it satisfied to the court that it is necessary in the for the rule of laws. So what is this means that the temporary injunction means a partial restriction from doing a specific act and can be granted only until a disposal of suit or until further order can be granted. Interim injunctions may be granted at any stage of the suits, like even before the service of summon to the defendant. So in this way we can understand what is temporary injunctions. So now we can say the injunction, we can say that the injunction, what objective of injunction. So injunction have two objective, which is it is a preventive in nature, restrictive in nature, and prohibitory injunctions, which means that from by temporary injunction or permanent injunction, one party can get a right of preventing other party or restricting or prohibiting from doing such party from any act which is satisfied by the court is in the favor of rule of law. That another is the mandatory injunction, which is giving someone injunction commanding or compelling or mandating someone to do something. So mandatory injunction are specifically governed by section 39 of specific relief act. So now we discuss that the CPC only deals with the temporary injunction. In CPC we only discuss what are the temporary injunction under the CPC order 39. सो द टेम्पररी इंजंक्शन का मेन ऑब्जेक्टिव यही होता है, प्राइमरी ऑब्जेक्टिव तो यही होता है कि किसी भी चीज़ को, अफेयर को फाइनल होने से या किसी को इनजस्टिस होने से, जब तक उसका पूरा केस डिसाइडेड हुआ कोर्ट से, जब तक उसके साथ इनजस्टिस ना हो, तो इसके लिए पहले ही उसको एक ग्रांट दी जाती है, रिलीफ मिलती है, वो अवेलेबल होती है पार्टीज के पास, कि वो इनिशियल स्टेज में कैन इंटरिम रिलीफ कैन बी ग्रांटेड बाय द कोर्ट्स. सो ये एक हेल्प करती है, एक एड की तरह रहती है और एंसिलरी रहती है टू द मेन रिलीफ अवेलेबल टू द पार्टी ऑन द फाइनल डिटर्मिनेशन ऑफ हिज राइट्स. सो ये ऐसा नहीं है कि ये चेंज नहीं हो सकता. इंटरिम रिलीफ कैन बी चेंज, इंटरिम इंजंक्शन कैन बी सस्पेंडेड और कैन बी कन्वर्टेड इनटू परमानेंट इंजंक्शन ऑन द डिस्क्रिशन ऑफ कोर्ट व्हेन इट इज एन एंसिलरी टू द मेन रिलीफ व्हिच व्हेन द फाइनल डिसीजन इज गिवन बाय द कोर्ट. So in this we can there is different type of interim temporary injunction also. So first is the ad interim injunction. ये कब ग्रांट हो सकती है? तो एंड interim injunction granted without final deciding on the application for temporary injunction or operate until the final disposal of application. So इसका मतलब क्या हुआ? एड इंटरिम इंजंक्शन अपन पार्टीज क्लेम कर सकती है बाय एन एप्लीकेशन इन द कोर्ट बिफोर एनी ट्रायल हैपनिंग ऑफ द सूट्स और बिफोर द फाइनल डिसीजन टेकन बाय द कोर्ट्स. So there is a specific rights given as a temporary injunction which can be given to court, and when the final disposal is happened, such relief can be converted into permanent, or such can be exit, or such can be struck down. So then another is the interim injunction granted while the final deciding the main injunctions application operate till the final disposal of the court. So the cases in which temporary injunction can be granted. So order 39 of the CPCs lay down the various situations in which the one party can ask for the interim injunction as a temporary injunctions. So order 39 rule 1 says that where is a suit is provided on a proof of affidavit, there are certain conditions, three basic conditions is given in this rule 1, that if the suit is satisfied these for three conditions, the temporary injunction can be granted. The rule 2 of this order says that where a defendant is about to commit a breach of contract or any other injury of any kind. So in this case also an interim injunction can be granted by the courts. So court may grant an interim injunction in order to, what are the basic reason behind giving the interim injunctions is to restrain such party from committing any evidence or damaging the evidence or alienating or selling or removal or disposal of any property which is in a dispute, dispositioning of plaintiff stands or cause any injury to plaintiff in relation to his property or in any dispute in the suits. So this can be said that it is in a favor of justice by preventing any harm done to the plaintiff, his property or any other material related to the suits. The period of injunction can be of depends on the courts. It can be until the disposal of suits or until the further order given by the court. It depends on the courts only. So the person who can apply for injunction is the plaintiff and defendant both can apply for the grant of interim injunction against the opposite party in a suit. So both the parties have these rights and there is no discretion between plaintiff or defendant. If there is any injustice, both can apply for the application for interim injunction. So the injunction can be granted only in a suit, not against the stranger. The party should be in the suit, not against any third party which is not related to the suits. So there is a prior given to this what can be comes under the temporary injunctions. I hope guys you like this video and understand what is temporary injunction, how it is governed under order 39 of this CPCs, and what are the various conditions in which satisfied can a court give a temporary injunctions. So thank you for watching this video.